Okay, let's make a start. Good afternoon to you, and welcome to this session in Family Mediation Week 2024, which is a discussion about mediation into arbitration. This session will be recorded and available for the next year on the FMC website. We will invite questions and we'll try and answer those as we go or at the end, and any that we're unable to cover, we will try and come back to people, and do add comments in the chat function. There are no slides because we thought you would benefit from seeing our lovely faces, but there will be some links and references that will be added to the chat. I anticipate that we have an audience that is a mixture of mediators, lawyers, arbitrators, and other professionals, and all are welcome. The presenters are all mediators and solicitors, and my colleagues are also all arbitrators, which is extremely helpful to us in terms of what we're considering today. I am Karen Barham, a mediator, solicitor and parenting coordinator, and a consultant at Moore Barlow. I'm joined by Karen Walker, who is the founder of her own firm, KGW Family Law, and Nadia Beckett, who is similarly the founder of her own firm, Beckett Solicitors. We were also joined by Suzanne Kingston, a consultant at Mills and Reeve, and at Carrie Olson, based in the Channel Islands, and Alison Ball, who is a partner at Mills and Reeve. We'll be going to be looking at the practical and procedural considerations for mediation to be moved into arbitration. To be quite clear, under this process and this model, the mediator and the arbitrator are two different professionals. We are not looking here at a model whereby these activities are performed by one professional fulfilling a sequential role. That is known in other jurisdictions as Med-Arb, and perhaps therefore for this purpose today we will call this mediation into arbitration. We'll be looking at mediation moving into arbitration where there are retained lawyers, and particularly where there are none. And our focus will be on the extended role of the mediator in assisting their mediation clients to move seamlessly into arbitration. Again, another caveat, there is no compulsion upon mediators to do this onward work. Our mantra as mediators is do no harm, and mediators must always work within their competency, know their boundaries, and operate within the FMC Code of Conduct, Practice, and Professional Standards. Mediation has, of course, evolved to include hybrid, also known as integrated practice, where other professionals, including the client's lawyers, can be invited to join sessions, and where confidences and secrets in the negotiations can be held by the mediator. Counsel or other experts can help inform the mediation by early neutral evaluation, for example. But however inventive and creative as mediators, there will be some cases that require a decision or some or all issues. We'll look at the distinction between financial and children matters, and we will just remind everyone that a properly constituted MIAM, in accordance with the FMSB standards, requires the mediator to explain all forms of non-court dispute resolution, NCDR, including arbitration. And we hope, therefore, that this presentation provides a greater knowledge about the arbitration process generally, and provides a framework for those mediators who wish to assist their clients to move to arbitration. So perhaps we can start, Suzanne, with you and the evolution of family arbitration, IFLA, and the two schemes, finance and children.
Thanks very much, Karen. Delighted to be here today. Just starting off with arbitration, that was something that had been thought about for about 20 years, but it was only in 2012 that the financial scheme for arbitration was launched, and that was then followed in 2016 by the children's scheme. And really, there are various stakeholders in the Institute of Family Law Arbitration, otherwise known as IFLA. By the way, that's a great resource and a great website if people are interested in finding out about arbitration. So ifla.org, a great website. And the stakeholders are essentially Resolution, the FLBA, the Centre for Family Justice, and the Chartered Institute of Arbitrators. And that group got together, formulated the rules, and there are two separate sets of rules. There's one for finance, one for children. The financial scheme really covers everything that a family law judge would be able to do, with some exceptions. The arbitrator isn't able to deal with the status of the relationship, insolvency, or third-party intervention like trustees without agreement. In the children's scheme, again, the arbitrator would be able to deal with most things that a family court judge would be able to deal with, apart from, again, the status of the child, abduction, adoption, and surrogacy. But all other things fall within the remit, and essentially it's private adjudication. The arbitrator makes an adjudication, which is in some instances signed off by the court, and then you have your full determination, your full judgment, as it were.
Arbitrators. Karen.
So I'm looking to discuss this afternoon the evolution of something called the Certainty Project, how that came into being. It really resulted from a conversation between a number of out-of-court dispute resolution professionals who were considering the fact that actually the clients have this sort of myriad of all kinds of different options to look at, which can become really quite confusing. And so we thought hard about what it is that clients really want to do when they come to us to have their disputes resolved. And in essence, we felt that they wanted either to be helped to achieve their own resolution, or they wanted someone to make a decision for them. And it really is as simple as that when you boil it down. And that gave them a certainty of outcome, either through their own decision or somebody else making that decision for them. And hence the Certainty Project was born. The way in which it works is that you would have initially an arbitrator appointed. So the arbitrator has an overarching control of the process. They are there to deal with any kind of hiccups that arise along the way, such as the wording of a draft letter of joint instruction, or some kind of direction over an interim issue that might arise that requires immediate consideration. But otherwise, they're poised to simply retain control of the process in that way, and to make an adjudication at the back end of the scheme if that were to become necessary. In the first instance, the couple will go, whether or not they've met with lawyers in the first instance, which I'll come on to in a second, but their first point of call, as it were, is the mediator. Now that can be in the classic model or hybrid mediation, whichever works better. The mediator will try to help that couple reach their own decision. Now they may resolve some of the issues, none of the issues. If they resolve all of the issues in that fortunate situation, then the arbitrator will simply prepare their award or determination by consent, whether it be financial or children. And so it will be recorded as an arbitration for the purposes of calculating numbers, but the arbitrator's role will be very limited and their cost will be very limited as a consequence. If they're required to determine just some of the issues, then a joint note will be provided to the arbitrator to show which issues have been resolved by agreement and which require adjudication, or the third and least favourable option, which is a complete determination or award, is that the matter passes to the arbitrator, who will then give their adjudication. Now, it's very easy to cost quote under the Certainty Project, because you take your worst case scenario first, which is the adjudication by the arbitrator, having first endeavoured to work with the mediator. And therefore, fees are likely only to reduce if a settlement is achieved at an earlier stage. So that's really beneficial both for the couple to know where they stand, and for the lawyers, if involved, to be able to cost quote right at the outset. Now, I said initially, this ideally involves solicitors who will deal with all of the disclosure first, so that the couple move to the mediator in an ideal world with an asset schedule already drafted, either completely agreed or highlighting areas of dispute. But if the couple don't have lawyers, if they really can't afford lawyers at all, it's still possible for the mediator and arbitrator to work together. I'd emphasise two separate individuals, to take the couple through mediation and then on into arbitration. You'll find all the details of how this works on the Certainty Project website. I know Karen will have put details of that in the chat bar, and also details of the individuals, mediators and arbitrators who are able to participate.
And that's enormously helpful. What you are doing there is exactly what it says on the tin, and provides certainty of a conclusion, of a supported mechanism to move through to a conclusion, and the certainty of staying away from the court.
Yes, exactly that.
Okay.
And also certainty of cost, which I think is also important.
Okay, thank you very much. Nadia, welcome. You have been instrumental in preparing an IFLA guide for mediators. You're probably going to wave it around. I'm not sure if you've got a hard copy there. Just tell us about...
I don't.
Okay. Tell us about that piece of work and how it came about, and the need that you felt it was addressing, because obviously this has been a piece of work that's been underway, I think, for some time. So tell us a bit about that, please.
Yes, Karen, thank you, and welcome everyone, and thank you for joining us today. I think it's quite. I sit on I co-chair the advisory committee to the Institute of Family Law Arbitrators. Suzanne also sits on the advisory committee, and over the years we've developed guides for practitioners. There's a guide. So I will refer everyone to the very helpful link that you posted, Karen, which is the website, IFLA website. On the IFLA website, you will find a practitioner's guide, which is aimed at solicitors. It's a practitioner's guide for solicitors and barristers for family arbitration. And you will also find a public guide. And those two guides give you quite a lot of detailed information about how arbitration works. But we didn't have a specific guide for mediators. And even though arbitration has been around for quite a long time, it's still quite clear that there is still quite a lot of ignorance about family law arbitration. It's still something that is either being touted as being most appropriate for wealthy people, not appropriate for litigants in person, only really relevant to people who live in London. Gradually things are changing, and the pandemic did make a big difference, because I find at the moment it's much easier to persuade other solicitors to consider arbitration, because, as we all know, particularly when you live in the southeast, there are dreadful delays in the court system. And so arbitration is now looking like a really sensible option for a lot of couples if they want to save a lot of time and save a lot of money. But we were very conscious that we didn't have a guide for mediators, and conscious that perhaps arbitration was not being discussed in the way it should be discussed during the MIAM process. And I'm sure there are a lot of mediators that are very familiar with arbitration and feel comfortable talking about it, but there are probably equally mediators who aren't, because it's certainly true of solicitors, even barristers I come across even now who still don't really know anything about family law arbitration. So the idea was to prepare a guide to help mediators understand arbitration better and how it fits in with can fit in with mediation, and to help mediators feel more comfortable talking about arbitration at the MIAM stage. Because, Karen, as you pointed out, of course it's not compulsory for a mediator to direct or push or navigate someone into arbitration, but it is actually something that mediators should be talking to their clients about at the MIAM stage, and that is potentially compulsory. And so therefore it's important to understand what it is you're talking about. So the guide, the mediator's guide, which I'm afraid isn't on the IFLA website yet, but it will be shortly, it doesn't go into details about how arbitration works, because those details are in the other guides. And so the public guide, the practitioner's guide, available on the website to give you more of the nuts and bolts of the process. The mediator's guide is really talking about, we felt, some of the things that perhaps would be of more concern to mediators, such as how domestic abuse plays into this, the role of an arbitrator in cases where there are allegations of domestic abuse, or safeguarding. So where does that leave us? The guide is there to help explain the benefits of arbitration for mediators and the way that mediators could be working with arbitrators. And I hope that when looking at the guide and thinking about this again, there will be a lot of mediators who could think carefully about whether they should be maybe teaming up with a friendly arbitrator that they know they can work with, to work together to help clients keep cases out of court. So a good example of, sorry, Karen.
No, I was going to say, thank you, Nadia. And perhaps what we can look at now are some of those procedural and practical considerations. I have absolutely no doubt, and you four are still in traditional practice, whereas I operate entirely as a mediator and a parenting coordinator, that you are explaining to your clients and to solicitors with whom you're dealing the benefits of arbitration, etc. And we wish there was more of it. I mean, it is a robust process, which is perhaps underutilized, but hopefully things are changing there. Let's look at some of those procedural and practical considerations, and what we thought might be helpful following the work that we've done in preparing for this are perhaps some more tools and precedents, possibly even some further training, and perhaps then we can invite sort of questions from our attendees today as to whether that would be helpful. Alison, can we turn to you as a practitioner and an arbitrator? How easy is it, or not, challenging, or are you pushing on an open door when you're explaining arbitration to solicitors that you're working with on cases?
Well, I think those solicitors who understand what arbitration is and how it works tend to be very positive about arbitration. I think one of the reasons why arbitration hasn't had more of a take-up is that very often delay favours one or other of the couple. The inquiries that I get quite often about arbitration, perhaps from people who don't have lawyers, they don't really understand what it is, and also they don't appreciate that the couple need to agree to arbitrate. So I think that's a bit of a barrier as well for those people who don't have lawyers. Certainly when I've talked with clients about it in mediation, there has been a mixed bag of whether it's been explained to them previously or not. And likewise, so if they have lawyers already, of course, I have to be mindful that when clients first take legal advice, they are bombarded with an awful lot of information, and then there is a state of understandable distress, and so it may well have been discussed and they've not really heard it. But it's been something that's been of interest, and the more difficult it becomes to rely on the court process taking place speedily and efficiently, and without things like, as I've just had this week, an in-person hearing suddenly being converted to an online hearing with no real notice, and in fact no one had even noticed that it was supposed to be an attended hearing, and you've got everyone lined up to come along to it. It's very, very unsatisfactory. So yeah, I think we'll see, won't we, how it develops, but I suspect that arbitration will increase as obviously understanding and knowledge about it increases, but also unfortunately as the court process becomes more and more difficult.
Okay, let's look at the procedural practical considerations if you are the retained mediator, and unfortunately you've been unable to assist the participants resolve all or some of the issues, and it needs a determination, and they don't have the appetite, and you don't think it's perhaps suitable for court, and we're then trying to appropriately encourage it into an arbitration to determine some or all of the issues. And I think here perhaps we can look particularly where the mediation clients don't have retained lawyers, so that effectively they will be litigants in person. Can I ask you, Karen and Suzanne, about some of the professional and boundary considerations that we would need to bear in mind as the retained mediator, where, of course, the mantra is do no harm, but where we're trying to be helpful to those, particularly where funds are perhaps limited.
Yeah, sure.
I think I should just start. Oh, sorry.
No, I was going to say you go first, Suzanne.
Thank you. I was just going to start by saying that because in arbitration you are getting a binding adjudication, it is really, really important that the litigants in person understand the binding nature of arbitration, which of course is different to mediation. So having an explanation of that, and also under the rules speaking to a solicitor who does inform them of that and then sends them back into arbitration, I think is really the way forward. I think that's absolutely crucial in those circumstances. There are other boundaried considerations, but I wondered if I should ask you on that note, Karen.
Yeah, I mean, I think the most important point is that there's a real danger, I think, of us wanting as family law professionals to be as helpful and accommodating as we can be. It's in our nature, it's part of the work that we do. But it's really important for our own protection as professionals and for the protection of our clients that we maintain the strict boundaries which our professional roles require, and that if we don't, that there's a risk that we fall into a very, very difficult situation. A lot of us wear different hats. So a lot of us on this webinar today are mediators and arbitrators and solicitors. But I think it's very important to always check with yourself as to the role that you are providing at any given time. If you are a mediator, you cannot give advice. And Suzanne makes a very good point that if you're going into arbitration, you need somebody to advise you as to the contractual and binding nature of that as a process. I think that mediators are able to give information. I think as at the point Alison made, is it's very, very important for whoever is the gatekeeper to any process to be able to, at a MIAM, for example, talk not just about mediation, but about arbitration and mutual evaluation and private FDRs and all the other tools that we have to resolve these issues. But if you are the mediator with no lawyers, it's very important that you think about your own position, make sure that you're giving very clear information, explaining what the options are, pointing out by way of information that advice ought to be taken before going into the arbitration, because again, the arbitrator can't give advice either. There are no replacement solicitors in this show, as it were. For very, very simple facts, if you have a couple with no money and a house and a pension and some income to divide, and the mediator just couldn't crack it, probably because the assets were so tight, nobody wanted to give ground. Probably an arbitration is the next sensible step, very, very cost effective and very time efficient, but so vitally important that the mediator looks at who is going to provide the information to the arbitrator. At what juncture do this couple need just a bit of proper advice? Might they benefit from it? It doesn't have to be expensive. And then they can move without representation, if they so wish, into the arbitration. And it can work extremely well. So I think as a model, it's very, very time and cost efficient. As professionals, we just need to be sure that we're not giving advice if that's not our role. And it almost certainly is not your role, whether you're the mediator or the arbitrator. Really important, I think.
And Karen, just to pick up on Nadia's point, I think we're showing that arbitration can be used in a whole range of cases. It's not just the preserve of the mega wealthy. It is possible to have a very small case with litigants in person. So it is possible. And that's something I think that we need to make sure that people understand as a consequence of this webinar today.
Thank you. And I think also And this may have been a case that came to you, Karen. We certainly need to provide a mechanism for people that would be self-representing to move into arbitration, perhaps where they don't have huge funds. But similarly, and again, as the mediator, where you have people that perhaps have some companies, several properties, eye-watering pensions, they're looking to save money. And so they'll retain a mediator who they might expect then to help them move seamlessly into arbitration. What do we do there about assessing suitability?
I think it's very important that we look at whether this is something that the arbitrator is going to be able to deal with. And of course, don't forget that the arbitrator at a pre-commitment meeting can decline to take on the arbitration. There are people out there who look for a cost-effective option when they've got plenty of resources to deal with things properly. And of course, the problem with that, if they come into arbitration unrepresented, with hot and cold running companies and offshore trusts and need company valuations, they need a pension sharing report, and they think they can sidestep all of that, that's going to cause a real problem for the arbitrator, and is something that certainly from my perspective I would decline to take on as an arbitrator with a couple coming along in person. But I reiterate the point that Suzanne makes. I think we need to take account of the fact that arbitration does work extremely well for small money cases. I think it was very regrettable that at the outset it was a little bit billed as being for the rich and famous and those who wanted the privacy. Actually, if you want something determined quickly and cheaply, and it's a simple point, arbitration is very much the easy way to go. But the flip side of that is that it's really not the place for the couple with very, very complicated finances who are then unrepresented, simply because the arbitrator cannot give them advice. They're not there to be lawyer and arbitrator all rolled into one. And I think it's important just to identify that difference.
Thank you. That's really helpful. Nadia, did you want to?
Yeah, I would add to that, I think, because I agree with everything that Karen said, but I would also kind of want to point out that, of course, as the arbitrator, we control the process. Now, the clients have more involvement in that process because this, it's an agreed process, but ultimately the arbitrator decides. And so I do a lot of arbitrations with litigants in person. And I'm often challenged on why do we need a code report? And my answer to that is because I've decided that I need a code report and you're going to get one. And they don't actually have a choice because I've directed that they get a code report. And that's what I need as the arbitrator to decide on a pension share. And that's what they've got to do. And they do accept that. So I do a lot of small money cases. I would agree it's clearly preferable for parties to be represented, even in not represented, but to have had advice at the very least, even in small money cases. I mean, I'm a solicitor. I believe everyone should take legal advice at the outset, just at least because information is power, and understanding, at least understanding your position and understanding what the future might look like is very important for our clients. But I think that we can't be, as arbitrators, we can't be frightened about dealing with arbitrations because a particular party doesn't want to have an expert report in a particular case. If they've signed up to the arbitration, they're committed to doing what you tell them to do, basically, what you direct, in the same way as they would be directed by a judge. I'd also say what I like about dealing with litigants in person, and there is a lot to like about that in my experience, is that I also undertake the resolution one solicitor two client model, the RT model. And what I'm finding really interesting is that clients like the idea of signing up with an arbitrator, different person, and then having the opportunity to negotiate a settlement through RT or mediation, because they want that opportunity first, but knowing that they have the safety of the backstop if the mediation or the RT doesn't end in an agreement. They know that the negotiations are never going to be weaponized. They're not going to end up in court. They're going to have a decision very quickly, and that can all be done in a kind of a fixed fee package for them in a way that I think clients find very appealing. So I definitely think that mediators should be trying to find arbitrators that they can work with so that they can offer that as a solution for clients. Don't wait until the mediation's broken down. Think about signing people up to arbitration first as a backstop and coming to an agreement with the arbitrator about fees.
Okay, let's talk about that. We've had a helpful question from Liz in terms of arbitrators' fees. Who'd like to take that? So just so that our audience have some idea as to, you know, perhaps a certain case at one end of the scale and another. And I absolutely, there is a range, but if we could have some helpful contributions on that aspect, please.
Suzanne's on mute.
Your mouth is moving, but there's no noise.
Yes. Sorry, what I said was I wasn't necessarily going to give some figures, but I did want to make it very clear that the majority of arbitrators, if not all of them, will give fixed fee quotes. So, and sometimes they do it on the basis of the arbitration and then separately how much the award writing or determination writing would cost, or they do it as a package. And Karen has already mentioned the pre-commitment meeting. And my really strong advice is that you should speak to 2 or 3 arbitrators in this circumstance, explain the situation, whether that's the lawyers explaining or their clients in person, if they're going to be litigants in person, and go through what a rough timetable could look like, and also what the fee quote would likely be, because I think that you should have a very good sense of that before you sign up. People were initially worried that arbitration would be expensive, but in fact, because people are doing fixed fees and adhering obviously to those, it hasn't worked out expensive. Also because typically you know what the landscape is, you timetable at the outset, you know how the case is going to evolve. And so unlike the court process where there may be lots of adjournments and delays, you deal with things quickly if you want to. And that means that you're in the situation of keeping well within the bound of the time of the cost, the fixed fee.
Thank you.
I would add to that, I think, I can say anecdotally, and it is just anecdotally, looking at the type of cases I've either arbitrated or where I've had quotes from arbitrators, where you're looking at a one-day arbitration, so preparation, one-day arbitration and writing the award, at the moment, generally in the region of £5,000. That's just, you know, you'll have an arbitrator, a complicated arbitration over 2 days, it might cost £20,000. I've had an arbitration that's where the arbitrator's charged £2,000. It just depends. But kind of my feel for it is typically they tend to come in at around, in the provinces, around in Kent, where I am anyway, around 5,000. But that's just a rule of thumb. It really does depend, and it's impossible to put a fixed figure on it. But I think everyone understands that.
Also, Karen, it's worth noting that arbitration can be dealt with on paper as well as having a hearing. So for very narrow issues, you might find that you would have an adjudication simply on the papers. That can be very much more cost effective and hugely time efficient. I think it's also helpful to add that most arbitrators will do a pre-commitment meeting, which will be free of charge if the arbitration doesn't go ahead. And so it doesn't have to be more than sort of 30 minutes or so, but it's a good opportunity to find out from the arbitrator's perspective whether it's a case that they want to take on, from the couple's perspective whether this is the arbitrator that they want to use, and everybody can scope out, as Suzanne rightly says, time and availability and so on. So I think it's really worth people investing in finding out what's out there, who's out there, and to take Nadia's point that if you find a number of arbitrators with whom you like to work, and you can then work regularly, you can create a working mechanism which can be hugely beneficial to your clients.
Thank you. That's enormously helpful.
I should add as well, the fee is shared. That's the general rule, just to make that clear. So the kind of figures I was talking about were for the arbitration, not per person.
Which if a couple are sharing 50-50,
Yes.
5,000 plus VAT, 2,500 plus VAT.
So it's exactly the same
Yeah.
process.
Okay. Can I ask you, Alison, as mediators, we're mediating a case, we have some issues that aren't resolved. Some people, as part of their mediation agreement, have the arbitration clause in there. And Angela Lake Carroll, and aren't we lucky to have her, has the specimen in the resolution handbook, for example, for resolution mediators. Can I ask you whether in your mediation agreement you have that in as a standard clause or not? I have my own preference, but I wondered what yours was.
I mean, yes, I put it in so that in the draft agreement, so that the couple can see what it looks like, and then we would discuss it as part of, as part of the MIAM, obviously, when we're I'm talking with them about all of the different options. I mean, I think the key thing here is to make sure that the couple have the information that they need to make their own decisions about how they want to deal with the issues they need to resolve. And if you don't have it in there, they don't know really what it is. So yes, that's the way that I work anyway.
Okay. Other contributions on whether you have the arbitration provision in your agreement to mediate as a standard in or out? I don't have it in because I tend to find that for people coming into mediation, understanding the principles, etc., that again, in terms of overload of information, is probably about as much as they, for some clients, can manage and want to commit to. So my practice is not to have it in as a standard clause, but of course other people's may be different.
I think I don't know whether it would help, Karen. I think it's really helpful to think about what happens when a mediation breaks down, and that's why the Certainty Project is so good, because inevitably the couple have come into mediation to try and reach an agreement, and that's what they've committed to. And by the time they get to a point where they've not managed to do that, inevitably emotions can be running high because one's blaming the other or whatever it is. And at that point, in my experience anyway, it's very tempting, particularly if they have legal advisors in the background, to end up going straight to court, which I think is why having this discussion around arbitration at the outset, and in an ideal world, everyone would have the benefit of being able to work with a lawyer, whether it's two lawyers or one lawyer, using the one lawyer, one couple. And it will be interesting to see how that could work in this sort of team working approach. But we'd have a lawyer, a mediator and an arbitrator who are all working together and know each other and have worked out a way in which we can do this cost effectively, very much like the Certainty Project. And there's no reason why we couldn't do that anywhere, but it just takes a while, doesn't it, to change the way that we work, because we're all used to working in a certain way, and any change is difficult for us, and we have to be able to explain it to our clients in a way that is normalizes it. Otherwise it's just another thing for them to be worrying about.
Karen, I think there's also the concern that particularly when you're dealing with high conflict couples, that they may engage in mediation simply to waste time and money and to prolong matters and to put the other person in a disadvantageous position. The same can sometimes be said for the private FDR, which is becoming a very sort of trendy out-of-court dispute resolution method, probably because it mirrors the court process so identically. But that because no decision is made at a private FDR, for the time-wasting, high-conflict individual whose desire is to achieve chaos and drama rather than outcome, it can be a very difficult and money-wasting exercise if you can use arbitration as a backstop. So you might say, yes, we'll go to a private FDR, but we're going to book an arbitration 4 weeks later, so no brief fees paid if the matter settles. but you've got your date and you make that as a condition. Similarly, really it's the point about the certainty project and having that backstop. If you've signed up to the arbitrator at the outset, so if you're time wasting in the mediation, then on your own head be it, because that arbitration is going to happen within a fixed time frame. So I think arbitration is a very useful tool to confine those who don't have a desire to achieve an outcome, who do just want to waste money and time, who do want to cause problems, because it shuts that down. And I think it's quite an underutilized method for achieving that, because you don't pay your arbitrator if they're booked until the date which their agreement says you pay. So it's very much the same as booking counsel. So you can have an arbitrator booked 2-3 months ahead. And if you do manage to resolve matters earlier, then no costs are incurred at all. But you've got that safety net in place. And I think it's really worth mediators or anybody who's looking at out-of-court methods, but where one of the couple may be just spinning it out and not really playing the game properly, to have that as a preventative position so that can be shut down.
The point at which the arbitrator is then in position, in role, and the matter is proceeding in arbitration for the person that maybe is playing games, etc. Could you talk to us about that mechanism? Suzanne, perhaps you could take that question from the point at which you've perhaps had a couple of beauty parades with arbitrators, timescale costs, etc. Opportunity for the potential arbitrator to consider the clients, but at a point in time there is then a commitment, and that couple are then locked into that process.
That's right. So they have been through the pre-commitment. They've decided which arbitrator they'd like to use. They then appoint that arbitrator, completing the relevant form. So if it's a children's scheme form, it's a children's scheme form, and a financial scheme form. And they make sure that that is sent to the arbitrator. The arbitrator then determines whether or not there needs to be effectively a directions hearing, a first hearing. And it may be that in a smaller case, there wouldn't be any need for that. Or it may be that the arbitrator, in discussion with the clients, have decided, as Karen's indicated, that this is a documents only and there won't be any hearings at all. I mean, that is rare, but that is possible. So you could have a short directions hearing, often at the convenience of the parties, whether that's, by which I mean whether it's in real life or on Teams or Zoom. And the arbitrator considers the various applications that are made by the parties or their lawyers, and then scopes out the case to bring it to a final hearing and gives directions to lead the case to the final hearing. And then you'll have obviously your final hearing date a month or 2 months, 3 months later. But what you don't have is you don't have the frustrating delays that we have in the court process. What you do have is your bespoke arbitrator who is going to stay with the case, who knows all about the case, who the parties can email. It has to be an email copying everybody in. It can't just be to the arbitrator on their own. It has to be copying everyone in. But that is such an amazing way of working to ensure that the parties have the ability to have contact with the arbitrator, who can then deal with any issues immediately as they arrive, rather than the frustration of the court process.
Okay, so a case has moved into arbitration, the arbitrator is case managing, etc. The previously, or maybe even still enrolled mediator, let's again go back to that scenario, there are no retained solicitors, who'd like to consider what the mediator can do in terms of assisting the couple with the preparation of documents, a helpful document for the arbitrator in terms of the issues, etc. Who'd like to pick that up in terms of what is appropriate for the mediator to do and what is going to be helpful to the arbitrator, again, where there are no retained lawyers?
I'm happy to answer that.
Thank you. Well, at the moment, you're the only person who's jumped in, Nadia, so we'll take your observations and thoughts.
I mean, I think the mediator would be doing all the things that he or she would normally be doing in the mediation. So if it's a financial mediation and there are no retained lawyers, the mediator is going to be helping the couple exchange financial disclosure. If there are issues about pensions, I mean, when I mediate, I tend to help couples get their letter of instruction done for their POD reports. I run through the process in the same way as I would really if I was acting as their solicitor, but without the advice. So, you know, if we need to look at property particulars, if we need to look at mortgage raising capacity, all those things that I would assume other mediators do as well in terms of helping a couple come to a financial resolution. Those are all the things that the arbitrator is going to need. So it's the same process, really. It's just a different way of dealing with the final decision, I suppose. But the process is almost identical to court. I mean, obviously, we don't need to be bound by using Form Z. Mediators generally, I would imagine, have either use the Form E or they might have their own version of it, something simpler, or they might use spreadsheets. But all of those steps that you would normally take.
Okay, thank you. Karen, I wondered if you were going to respond there, Suzanne, maybe Alison, in terms of a statement of the issues. Would that be helpful? Would it be appropriate? What could be in? What wouldn't you expect to see there? Alison, I think your lips are moving the most.
So I think, you know, from a mediator's perspective, as Nadia said, anything that would go in your open financial statement, there's no issue with the mediator dealing with that. Those are, you know, that's an open document and that can be provided to the arbitrator. I think when it comes to helping the couple to identify the issues that they need the arbitrator to determine, then you're starting to move into a slightly more tricky area, because how those are phrased and how they are formulated, you can imagine if each of them had a lawyer, then they might do that in a different way. So I think in order to help the clients, then a statement of what those issues are is not a problem. But we just have to be very mindful of, as mediators, that we can't give legal advice. We can give legal information, so we could explain why in without prejudice discussions in mediation, why phrasing an issue in a particular way might have implications. At the end of the day, the couple are going to need to decide what they are prepared to tell the arbitrator about what those issues are and understand the implications of doing so. And there is a boundary, I think, with what the mediator is able to do. It's very difficult, I think, to prescribe what that is, and it will vary in different cases depending on what the circumstances are. But as mediators, we need to be very mindful about that, and make sure whatever that the clients are making an informed decision, if they are then going to present to the arbitrator what is in effect an open list that can be referred to and will be determined by the arbitrator in a binding process. But whilst I agree that we are very keen to help people, and all of that's and we have to be very careful not to overstep the mark. There is inevitably a grey area, and different practitioners will work differently within that grey area. And as things stand, we're yet to see whether that presents an issue and where that boundary line is, where it becomes a problem.
Okay, and it led me, I think, in our pre-planning discussions to think that, and certainly as a mediator, it would be helpful for me to perhaps have some various precedents to think about this, to consider the boundaried way in which we can work, to hear from arbitrators as to, again, if there are no retained lawyers, what could be helpful and appropriate for the mediator to prepare to assist the client couple on their journey. Karen, I don't know if you had anything else to add to that particular point, perhaps looking at it as an arbitrator as to what might be a helpful suite of documents from the mediator, that it would be appropriate to leave the mediation and to come onto your desk as an arbitrator.
Well, I think a great deal depends on the difference between open and privileged documents that emerge from the mediation. So there will be open summaries, just as when we complete a memorandum of understanding and an open summary, there will be open information that can be in the common arena that can very helpfully be passed to the arbitrator. So the asset schedule, the financial documents, if it's a money case, or some factual information that's openly available in children proceedings. And so obviously that can very easily be ported by the mediator from the mediation process into the arbitration. I agree with Alison that I think where it becomes more difficult is when the couple are providing information which within the mediation is privileged. They haven't reached an agreement, so they're still under the shroud of mediation privilege, if I can call it that. And especially if they don't have lawyers, what advice, because it may well need to be advice, takes them to provide further information on a joint basis to the arbitrator. So I mean, yes, if let's say they've agreed some things and they want those elements to come out of the mediation privilege and be clear binding agreements between them, but there are still some issues to be resolved. I mean, I had a case some years ago where I wasn't the arbitrator, I was actually one of the solicitors in a situation which was being mediated, but the couple agreed everything except the quantum and duration of spousal maintenance. So they had a portfolio of properties, they agreed on how to split the house, they agreed on the pension share, they agreed that there should be spousal maintenance, just couldn't agree on the duration and the term. And so what happened there was that the two lawyers, of which I was one, did a document for the arbitrator in discussion with the mediator who provided the memorandum of understanding. The couple agreed that the agreed elements would become a binding agreement, and they asked the arbitrator to make just this very, if you like, simple decision against the background of what they wanted to stay in place. Now, how you would cover that if you didn't have the lawyers, I think would be difficult, because I think personally, and I'm happy to be proved wrong, but I think the mediator can only give information about what the options could be. But I think they're overstepping. Now, I'm going back to my point about being helpful, which is what we all want to be, and to save people money, especially when they haven't got much money. 99 times it might be okay, but it's the 100th time that isn't, that we put our professional reputation on the line. And that's why I think I agree with you, Karen. It would be really useful to have some documents and some very, very clear and boundary guidelines to protect us as much as our clients. When I was a very young solicitor, my principal told me, you protect yourself, your firm and your client in that order. And I think there's a great deal of truth in that.
Well, that self-interest is a very powerful thing, but we can see, can't we, where people are using one professional, a mediator who is perhaps braver, bolder, wants to help. There is a point at which we can overreach and it becomes unethical. And so I think we do need to consider those issues. And again, doing this work as a mediator, sort of encouraging on appropriately with the appropriate documents, the mediated couple into arbitration is work that is not going to suit every mediator. There is no compulsion to do this follow-on part. There are issues about the nature of your retainer, the fees, how much work you do in advance of an arbitration, and then of course no arbitrator wants to touch it, etc. What goes beyond the mediation, over the mediation wall to an arbitrator, etc., etc. And I suppose there, and I was going to leave a couple of minutes for questions. We've 4 minutes to go. Is there a continuing role for the mediator once the matter is in arbitration for matters to come back into mediation, although they're being arbitrated? I think there's a role there.
I think it can be, but can I just really quickly, I just wanted to pick up from what we've just been talking about. I think we have to be careful about making in this conversation it sound as though, I know you've been very clear, Karen, there's not an obligation for a mediator to follow onto arbitration. I think that's the point. From my perspective, the way I would see it as an arbitrator is that the request for financial documents, the request for information is from the arbitrator to the clients, not the arbitrator to the mediator. So I wouldn't be asking the mediator to disclose anything. I would be asking the clients to disclose. And so it has nothing in that respect. I would hope that there would be no suggestion that there would be any ethical difficulties for the mediator, or that I would be asking the mediator to do anything that they couldn't do. So I just wanted to kind of like make that point very clear. But your question was actually probably better answered by somebody else.
Well, I think that that's absolutely right. But again, we know that the clients will often sort of lean into us to be as helpful, which does risk blurring the boundaries. Are the opportunities for mediators to remain there for matters, even though the case is being arbitrated, to come back into mediation at an appropriate time? But perhaps I can ask you, Suzanne, at the end of an arbitration, which leads to an award on financial matters or a determination on children matters, the role of perhaps a single professional, which could be a single lawyer working under the resolution together, or another role, or the mediator, to help then by completing, for example, a parenting plan. Are there opportunities for a mediator or other single professional at the end of an arbitration?
Oh, I think
once the dispute has been adjudicated by the arbitrator, the dispute that's presented to the arbitrator, then there's absolutely no problem if there's another issue like the parenting plan for the mediator to become involved again and undertake that. I think that would be really welcomed. And just bear in mind as well that in arbitration you can deal with just parts of the dispute. You don't have to have the whole dispute. There might be a discrete issue that's being arbitrated, but everything else is subject to mediation or negotiation or whatever.
Okay, thank you. I think this has been a really helpful. I mean, it's certainly helped me as a mediator in terms of what I would feel comfortable to do or not. I do think we need some documentation, perhaps some precedents in terms of that follow-on piece of work. And I hope that that would be helpful to those that have attended today. I suspect the next thing would be I will take this back to Resolutions DR Committee and with colleagues here to think about what some of those materials might look like, to include possibly an addendum to the resolution handbook. And of course, we can't see all the lovely attendees there, but it may well be that the offer of some training on that specific role of a mediator into an extended role, and some of the practical procedural considerations, etc., may be training that people may find helpful. We've had some questions. There's one from Fiona Reid. Thank you for your questions. Is there any appetite to change our scheme into, for example, the Canadian Med-ARB, which is a seamless process with the same professional in role? That's not what we've looked at here. That may be being considered by IFLA. I'm sure if we were going to start that discussion, we'd be here until 6 o'clock at night. And there are a couple of questions from Anita. What is the advantage of going into a great deal of information on arbitration at the beginning of a mediation, etc.? We do need to conduct our MIAMs in accordance with the Family Mediation Standard Board standards. They are expected to take 45 minutes, an hour or so, covering all forms of non-court dispute resolution. And I suspect that in terms of the changes that are coming in on the 29th of April, the out of court space is going to become increasingly populated. People do need to know what is available, and solicitor practitioners will need to file a court at form when asked, why aren't you in a non-court dispute resolution process? I hope that'll be a topic perhaps for another seminar. I hope this has been of interest. And I suppose watch this space. But if there are perhaps some material, some further training, etc., we will keep people informed. So it falls to me now to say thank you very much to our colleagues. Thank you to Katie Deans in the background from Our Family Wizard, who has provided the technical support for today. And thank you to Our Family Wizard for their support throughout the year, and particularly during Family Mediation Week. Enjoy the rest of your week, and thank you.
Bye.